Chapter 3. Hiring an attorney. Outside sources are underlined in blue text. Forms available in our Forms package are underlined in red text. Links to each are below this video. Before you hire an attorney, whether to represent you or to consult with as a pro se litigant, work Lawsuit Analyzer so you understand what lies ahead and whether it makes sense to add another potentially expensive and complex element to your dispute, an attorney. When should you hire an attorney to represent you? Although this course focuses on handling your legal dispute pro se or with limited attorney involvement, the following situations may warrant representation by an attorney. When your dispute will have to be tried in the upper civil courts, which handles civil cases above small claims court limits. When you do not feel sufficiently competent to represent yourself. When an attorney fee provision entitles you to reimbursement of your attorney fees if you prevail. When your case value warrants legal representation. The upper civil court is your forum. Given the complexities of the upper civil courts, as distinguished from small claims court or alternative dispute resolution, you will most likely choose to be represented by counsel, whether you are a plaintiff or defendant. In this course, we use a metaphor of the House of Horrors for the upper civil courts to emphasize this point. Our chapter on the upper civil courts presents every conceivable way to detour your case out of the House of Horrors before you are prey for the wolves. The House of Horrors. Whether you are the initiating or responding party, the upper civil courts mandate legal rules and practices that are best tackled by an attorney. Both a complaint and answer to complaint must conform to a full array of legal checklists. Once you get past this pleading stage, you plead your case, the discovery stage, which we refer to as the litigation frenzy, gobbles you up. These requirements are so complex that even trained attorneys are challenged by them. While the courts have begun to cater to pro se litigants, especially since the coronavirus pandemic when court was out of session, the challenges of the House of Horrors are so intense that you should do everything you can to detour into alternative dispute resolution or small claims court. If you do not feel comfortable representing yourself, always consider hiring an attorney to represent you when you don't feel comfortable representing yourself. Most people would never consider self-representation, while others are able to step into this role with ease, after considerable research, of course. Consider how much being represented by an attorney is going to cost and whether it is financially worth it if there is no attorney fee entitlement in your case. If you have an attorney fee provision. If you have a written agreement with your adversary stating the winning party in your dispute will receive an attorney fee award, seriously consider hiring an attorney to handle your dispute. This assumes that you have performed the collectibility assessment described in a later chapter on and determined that your opponent is likely to financially respond to any judgment you may obtain. Smart cookie tip. Even if your attorney fee provision says that only one party is entitled to fees, in many states this one-sided provision is held to apply to all contracting parties. So don't let a one-sided provision scare you off. If you signed the contract, the fee provision probably applies to you, too. Warning: attorney fee provisions can work against you. Always keep in mind that these provisions can be a double-edged sword. It all depends on who wins. If you thought paying attorney fees is expensive, wait until you must pay your opponent's fees as well. Thus, you need to analyze your case from both perspectives, as a winner and as a loser. Always wear your devil's advocate hat. Ask yourself, what are my chances of losing, and paying not only my own attorney fees, but my opponent's as well? If you have a high-value case. If your case value is sufficiently high, you should also seriously consider hiring an attorney. Although the expense of retaining counsel will cut into your recovery, the expense may be well worth it with a case of high or reasonably high value. Hiring an attorney to mentor you, not represent you. One of the best uses of attorney services is to partner with them instead of having them represent you. Your attorney can guide you through the process with as much or as little participation as you need. An attorney mentor can evaluate your case, provide you with applicable law, prepare a small claims claim, prepare mediation or arbitration statements to summarize the facts and law, identify exhibits that support each, and much more. You do the legwork, they do the desk work. This approach can give you the confidence to present your case clearly and briefly and limit the funds you will pay for an attorney. A productive way to begin this partnership would be to work your case through Lawsuit Analyzer and review your results with your attorney choice. This will give the two of you a professional basis to perform job delegation between the two of you. Hiring an attorney to represent you. If you've decided to hire an attorney to represent you or partner with you in some manner, review your Lawsuit Analyzer results first. Only after you complete this thorough evaluation will you know whether you should hire an attorney to represent you in your dispute. Review your legal evaluation to ensure that your case is feasible. Review your legal options assessment, which assesses attorney fee reimbursement, discussed above, and forum identification. Review your collectability assessment. What are your chances of actually collecting your attorney fees, if you win and are so entitled, from your opponent? Review your feasibility analysis carefully. Does it indicate that it is worthwhile for you to hire counsel in the manner you are contemplating? The legal education gained through working Lawsuit Analyzer will also enable you to intelligently discuss your case with your attorney candidate. You will already have the answers to the most important legal and financial aspects of your case. The legal crux of your case. Your case value. Your settlement value. Which forum will decide your dispute? Whether you are entitled to get back your attorney fees. Legal consumers are beginning to interview their attorneys in more depth. But many more questions need to be asked and instructions given. This person is going to represent your interests in a very important way, and payment for their time could be exorbitant. There are two primary issues to consider to obtain the best attorney for you and your case. 1. Finding an attorney with good reviews experienced in your dispute. 2. Interviewing your potential candidate with questions that matter. Step 1. Finding an attorney with good reviews experienced in your dispute. First, you need to determine the area of law your case fits into. Search the internet to determine this. Is your case about a personal injury, breach of contract, real estate, wills, and trusts? You want to locate an attorney who specializes in that area of law. Next, you want to locate an attorney with good reviews within that area of expertise. These days, with reviews available all over the internet, the very best way to locate a quality attorney specializing in your type of dispute is to perform an internet search. For instance, if you are looking for a real estate litigation attorney in San Francisco, California, type in your browser, "real estate litigation attorney in San Francisco, California" to find attorneys with reviews. Smart cookie tip: choose the highest reviewed attorney and really read the reviews. Get to know that attorney and the quality of their work. In days not so long ago, you would call your local attorney referral service and they would refer you to an attorney in your area focused on the area of law of your dispute. Or, you would ask friends for the name of an attorney they have hired. Those days are gone by. Do the internet search as described and you will have a wealth of information about local attorneys and the quality of their work. Step 2. Interview your potential candidate. Although you found an attorney who specializes in the topic of your dispute and has a number of good reviews, you need to interview your candidate to ensure that you feel comfortable working with this person. You are going to spend a sizable amount of time and money on this person. You want to make sure they can work with you as a team. Will they take the time to explain in lay terms why a certain step is being taken and its cost-benefit ratio? You want to make sure this potential team member will listen to you and be guided by your input, especially when it comes to cost control. And, finally, if you truly like this person and get along well, the litigation experience will be far better for you. This checklist can be significantly abbreviated if you plan to be mentored instead of represented by your attorney choice. Your attorney interview checklist. These are the questions we suggest you ask of your attorney candidate. 1. How long have you been practicing law? 2. Do you carry malpractice insurance? May I see proof of coverage? 3. Do you encourage clients to consider alternative dispute resolution? 4. Have you been trained in alternative dispute resolution? 5. Do you have the time to dedicate to my case? 6. What qualifies you to handle my case and the type of my dispute? 7. Do you have written recommendations from other clients that you can share with me? 8. May I review your resume? 9. If you are unavailable in trial or deposition, who will respond to my inquiries and take care of my case? 10. Are you willing to work with me in tailoring my case to my budget? Of course, I will provide you with written authority if I decide to forego a certain strategy or tactic that you recommend. 11. I am interested in keeping my costs down in this case. Thus, I want to participate in discovery decisions with you, and to undertake some tasks in my case if I am able. Is this agreeable to you? 12. Review your lawsuit analyzer results with your candidate. Performing this review with your potential candidate achieves 3 ideal results. First, it explains your case in depth. Second, it allows the two of you to have an intelligent quasi-legal conversation about your case. Third, does this person agree with its results? 13. What do you see as the downside of my case? 14. Are you willing to entertain a fee structure different from an hourly charge, such as contingent fee or part contingent fee and part hourly fee? 15. Are you willing to roughly estimate how much my side of the case will cost without considering the other side's strategy? 16. Will you now provide me with an itemized estimate of how much you feel it will cost to defend just my side of the case? I will not hold you to the estimate, but I do want to get a reasonable idea of the costs we are talking about. Once you have completed this checklist with your candidate, you will know whether you want to hire this attorney. This interview process usually takes an hour and 1/2 to 2 hours. You will want to pay for the remainder of the interview following any free consultation. This type of interview goes beyond attorney biography into legal analysis. Thus, you should not expect a free consultation for more than 1/2 hour or 1 hour at most. Even if you don't hire your candidate, you will presumably obtain a valuable evaluation in your interview process. It will be worth the hour or so of paid attorney time. Making decisions with your attorney. You and your attorney need to discuss the roadmap of your case and the many ways it can be handled. There is an economical way of representing someone called basic representation. Here, you get basic legal steps, but no frills. Then there's full charge representation where the cost is usually prohibitive. There's a range in between. You and your attorney should discuss each of these methods, and you should provide instructions about which method you want. You can only make an informed decision through clear attorney-client communication. Attorney fee agreements for litigation. Get ready to review a full gambit of fee structures for attorney representation in litigation. Hourly fee agreements. If you have the financial ability to afford an attorney on an hourly basis, you will most likely pay the lowest fee since it will be tied to time, as long as you carefully control time. On the other hand, it would be the most expensive if you lose your case when compared to a contingent fee structure where if you lose you pay nothing. Also, with an hourly agreement you will not be able to test whether your attorney believes in your case enough to invest in it on a contingent basis. Contingent fee structures. When you are the party seeking a recovery, you should consider asking your attorney to handle your case on a contingent fee basis. A contingent-based fee arrangement will free you from payment as you go along and will free you from payment entirely if you lose. With a contingent fee arrangement, you and your attorney share the risk and rewards of your case. If you win, they share in the net recovery in the proportion agreed to in your contingent fee agreement. If you lose, your attorney does not get paid, nor do you. Contingent fee arrangements are fully negotiable between you and your attorney. The percentages can be whatever the two of you agree upon. Though varying widely, contingency works as follows. Generally, you pay the necessary case costs, which typically include case filing, service of process, deposition costs, and expert fees. These costs are reimbursed before net recovery is determined. Net recovery is then split between client and attorney according to their agreement. An example: your attorney agrees to handle your dispute on a contingent fee basis with net recovery to be split 40% to attorney and 60% to client after costs are reimbursed. Recovery of $45,000 is received in your case. You are also awarded attorney fees of $7,000. Although the fee agreement is contingent, the attorney still keeps track of their time for calculation of an attorney fee award if there is a provision entitling you to attorney fees if you win. Your gross recovery is $52,000. Costs of $3,600 were paid by you, leaving $48,400 as a net recovery. Your attorney receives $19,360 as fees and you receive the remaining $29,040. The bottom line is you've recovered about $20,000 less than your damages. However, you didn't have to pay attorney fees along the way, and you recovered a substantial portion of your damages. If you had not won the case, you wouldn't pay your attorney anything, a far better result than a party who paid the attorney $7,000 and lost. In this scenario, the client would have been far better off to pay attorney's fees as he went along if he did indeed win, but if not, he would have been out the $7,000. Nothing is etched in stone when it comes to contingent fee percentages. Just as real estate agents negotiate their fees, or they should, attorneys can too. Work the numbers before you sign a contingent fee agreement. See what works for both of you. Contingent fee in stages. Agreements can also be staggered, for instance, 15 to 25% to your attorney if the case settles before filing suit, 20 to 30% if after lawsuit filed, 25 to 35% if after trial setting, 30 to 40% if after trial begins. These are ranges. Choose the one fits your case and budget. Smart cookie tip. Remember, you are boss. It is your case. Why not have your attorney paid commensurate with the time they have spent? Your attorney should believe in your case. Your attorney should believe in your case, or advise you that your case is not very strong. The best way to get your attorney's honest opinion about the merits of your case is to ask them to take it on a contingent fee basis. If they refuse to do so, chances are your case is not a winner. Otherwise, your attorney would be willing to share in its dividends, unless they have a good reason other than the validity of your case as to why contingent fee is not a preference. You need to come right out and ask. Smart cookie tip. Share your collectibility assessment recommended by Lawsuit Analyzer with your attorney. They may have concern that the judgment will not be paid by your adversary, which would be alleviated by your research indicating otherwise. Advantages of contingent fee. One reason why the contingent fee arrangement may be a solution for you, especially if there is no provision for recovery of attorney fees, is that you pay no fees if there is no recovery. In this situation, if you are the loser at the courthouse or at arbitration, your loss ends there. You haven't paid substantial attorney fees just to climb aboard the loser's seat. Losing feels bad enough without paying mounds of attorney fees to get there. If you're the winner, your attorney properly shares in your reward, and generally, his share is more than he would have received if paid by the hour. But your attorney has taken a gamble. Knowing she'd get nothing if you lost, the attorney deserves more for taking this risk. Although there are downsides and upsides to contingent fee agreements, sometimes they are the ideal answer, especially if you can't afford to pay your attorney as you pursue your dispute. Disadvantages of a contingent fee. There is a conflict of interest inherent in representing clients on a contingent fee basis. This conflict crops up in several ways. Impartiality may be at stake. A final settlement amount should be decided by the client. Usually, the client's decision is based upon attorney advice. When the attorney fees depend upon the amount of the settlement, the attorney confronts a conflict of interest. Her conflict: the more the settlement goes up, the more the attorney will get. If the attorney's desire for higher fees gets in the way of his impartial valuation, he has a conflict of interest. Clients may hesitate to dismiss a case. A conflict of interest appears when the client decides to give up his case for emotional or financial reasons. For instance, the case has proceeded for a year now. The client feels emotionally and financially drained by the process. She wants to dismiss the case and just move on. Without a contingent fee arrangement, it is entirely up to the client whether to continue to pursue the case. On the other hand, when the attorney has a share in the ultimate recovery, the client feels more inclined to proceed forward, despite the emotional and financial drain. Some contingent fee agreements contain provisions that help avoid such conflicts of interest. They state that if the client dismisses the case without recovery, the client will pay the attorney on a reduced hourly basis. If this is the case, no conflict of interest occurs. These are important factors which should be considered when entering any contingent fee arrangement. The combination agreement. There are many variations to the strict contingent fee agreement. Suggest something different to your attorney candidate. A combination reduced hourly rate and contingent fee agreement might work well for both of you. For example, half of the attorney's customary hourly rate and half of the customary contingent fee percentage. These agreements are completely negotiable and should be tailored to each individual case. Smart cookie tip: sit down with your attorney candidate and evaluate the probable outcome of your case. Then work up a mutually agreeable fee arrangement based on that figure. The increased hourly rate contingent fee agreement. This agreement structure is sometimes preferred by both clients and attorneys for contingent fee matters. The attorney's contingent fee compensation is tied to the hours he puts into the case. In this manner, both client and attorney know they're not giving or taking too much. The attorney keeps careful track of their time, and if you win, they receive their total hours multiplied by an increased hourly rate. Since the attorney is taking a risk, if there is no recovery or no collection on the judgment, they will never be paid. They should be compensated more than the regular hourly rate. How much will the increased hourly fee be? It's up to the two of you to decide up front. 25% more? 50% more? If the client wins and collects, the attorney gets paid for the time he put in at the increased rate. If there is no recovery, the attorney gets nothing. Smart cookie tip: review your attorney's time tracking as you go along to make sure your estimated recovery is in line with time spent. Estimates for litigation. An attorney will not be able to give you a fixed fee for litigation services because there are too many variables for how much attorney time your case will require. Unless your case goes to binding arbitration and there is a provision for no discovery, there are too many tools that can be used as strategies by your opponents. Will they take depositions? How many? Will they demand document inspections? How lengthy? For the binding arbitration proceeding with no discovery and sets a limit on how long the hearing will last, an attorney can generally predict the costs and fees. Otherwise, predictions are impossible. What your attorney can estimate is how much your side should cost based on the discovery decisions you will make together. Will you be taking depositions? How many? You and your attorney can discuss the legal procedures available, decide which ones you will be using and estimate the cost for each. Through this type of careful analysis, your attorney can provide you with a very rough estimate of the minimum cost for your side of the case, not including your opponent's strategies and your responses. Of course, the one unknown variable will always be the opponent's discovery plan for interrogatories and depositions. Some attorneys want to take depositions of all parties and all possible witnesses. Some attorneys take a deposition in a few hours. Others take the same deposition in 8 hours. When your opponent is not yet represented, the personal style of your adversary and their attorney is an unknown in the fee equation. For these reasons, your attorney cannot predict how much time will be spent responding to your opponent's discovery. But fees to be generated for your discovery plan can be estimated. When you are involved in litigation or arbitration with a provision that allows full discovery, you won't be able to pin down the bottom line for discovery costs and attorney fees. However, you will have a rough estimate for your own plan. There's really nothing more you can do to estimate fees in this situation, except to carefully proceed through every step, evaluate the case and costs as you move along, and take part in all decisions. Strategy and cost control sessions. You should have regular meetings with your attorney to evaluate your case as it progresses in terms of strategy and finances. If you are paying on an hourly basis or quasi-hourly, have this meeting upon receipt of an invoice. Remember that each day you have an opportunity to make a new decision for your case strategy, just as each morning when you wake up you have new opportunities to make changes and direct your day. This is another aspect of taking responsibility for your legal matter by participating fully in the decisions involved in your case. Conclusion. There will be times when the best course of action is to hire an attorney as a mentor or to represent your interests in your case. That's where this chapter comes in. Having expert guidance during darker days can make all the difference, as long as you plan ahead, especially when hiring your legal representative. Now that you're in the driver's seat for steering your dispute to resolution, you'll have the right attorney on board and will have the best chance to come out of your dispute on the winning side.